My name's Claire Waldeck. I have a law firm called Waldeck Attorneys, and we specialize in intellectual property law and commercial law. So a very important aspect of intellectual property that I find many people aren't aware of is the protection that's afforded to one in terms of the Copyright Act. Now, in terms of the Copyright Act, there are a number of works that are protected under the Copyright Act, and examples of those works include artistic works, literary works, sound recordings, broadcasts, musical works, just to name a few. In order for copyright to subsist in a work, what is required is it must be reduced to a material form. It must be original, and it must be made by somebody in South Africa or a person that's a member of the Berne Convention. But for our purposes, you must be a South African person. So what's so interesting about copyright is that it doesn't have to be registered anywhere. Unlike the trademarks, which are registered at the Trademarks Registry, copyright vests automatically. The only time you need to register copyright is when you're dealing with a cinematograph film. What's important when it comes to copyright is that depending on the nature of the work that's created, that depends on who the author is. So for example, if you're an artist and you've created a picture, then you own the copyright in that picture. But if you are a computer software designer and you've got a client who says to you, I want this picture to jump up when I do this, and I want the software to be able to do that, the person who makes and directs the controlling of the software program, that is the person who owns it. So it's extremely important when you are starting out on a business. And for example, if you are wanting to go and see a graphic designer or a logo designer or a website creator, if you give them a brief and you ask them to come up with a logo for you and they draw that logo, because they are the artist, they will own the copyright vesting in that logo. And unless you take assignment of the copyright in writing, it's one of the very few agreements that must be in writing, like a will or when you buy your house. If that agreement is not in writing, the artist will continue to own the copyright in your logo, even though you've paid them for it. So it's extremely important for entrepreneurs and creatives who are going out there and getting logos created for them to make sure that the person that creates the logo for them assigns the copyright in the logo. Now, what's lovely about copyright is it lasts for a long time, 50 years from the death of the author. So that's the reason why you can put a picture of the Mona Lisa on a handbag. The author has died, and so now that work is available to be used by the public. But while the author is still alive and for 50 years after their death, unless you have the person's permission or consent to use the copyright vesting in their work, you're not allowed to use it, and it's copyright infringement if you do. If you use somebody's copyright and you know that you're using their copyright and they've told you not to do that, it's also a criminal offense in terms of the Copyright Act. And so it's very important to make sure that you only deal in genuine goods and not goods that are infringing copyright. So, as I mentioned before, copyright is not registered anywhere except for cinematograph films. So if, for example, you wrote a script and you wanted to make sure that you had protection in that script, you as the author, if it's an original work and you've reduced it to material form, and if you're from South Africa, which is a member of the Berne Convention, copyright subsists automatically. Now, there are a few tricks that you can put into your work that can protect you. So, for example, you would put a copyright notice at the bottom of your work, which is a C in a circle, your name or the name of your company, and the date in which you created it. There's also, in the past, what people have done is they have emailed themselves or mailed themselves a copy of the script that shows when the work was created, and that will just help you down the road if we ever need evidence to prove when the work was created. But something that you can also do, especially when it comes to software developers, and even in literary works, is you can put little footprints or watermarks in your literary work that can help you identify that this work actually was created by you. So for example, an extra full stop on the third page, a misspelled word if you're doing a manuscript or something like that. There was a case many years ago where one company slavishly copied another company's diary and used the exact same telephone numbers that were at the back of the diary, and without bothering to check them. And what they had done is they had used a telephone number that no longer existed as a footprint, as a watermark in their diary, so that they could easily tell if somebody else had copied them, and this company had. And that was a nail in the coffin for them, to show that they had just slavishly copied and that they hadn't created an original work. So you could do that similarly if you were a software developer. You could write a piece of code and put it into your code that you're writing, so that if that code is replicated by any third party and that identifier code appears, that would immediately indicate that they have just copied you without applying any original thought. And copyright can subsist even in a sentence, so it's very important to make sure that if you do use somebody else's words or copyright, that you at least acknowledge them. And there are instances in the Copyright Act that allows you to make use of text. For example, if you are quoting out of a textbook or you're doing research, as long as you acknowledge that it's not your work, but that somebody else's work has been created, and that you are acknowledging their rights in that work. So in order to protect musical works, if you have an example of somebody who has come up with a beat in their basement, for example, and they're wanting to approach a record company, you must remember that ideas cannot be protected. It's only once it's reduced to a material format. So when it comes to songs, there are a number of separate copyrighted works that are making up the elements of the song. You've got the lyrics, you've got the sound recording, you've got the actual musical work that's created. And once that's all together, that's what's creating the song. But each one of those elements are protected by copyright as a separate element. So for example, if you wanted to go and take your demo CD with your beats or music file, and you wanted to go take it to a third party, my first advice would be that you sign a non-disclosure and non-circumvention agreement. That is a document that you should have in your business at all times. Whenever you're a creative person and you're coming up with ideas that you're wanting to share with third parties, you ask them to sign a non-disclosure agreement, which says that I'm about to tell you some confidential information. Don't use my confidential information, and don't circumvent me. If you're not going to use it, don't go ask your friend to now make this song after I've given you the information. So that would be a starting point, is to sign a non-disclosure, non-circumvention agreement. Then when you go and take your beats to the producer or so forth, you would let them listen to it. You obviously wouldn't leave a copy with them there. Sometimes in the beginning, when you're just starting out, you may be forced to leave a copy there, and you'll have to decide for yourself. But the way in which you protect your rights is, once they've signed, or once they're wanting to use your work, you would have to assign the copyright that you own in that song to them. Or if you don't assign the copyright and you keep the copyright for yourself, you can always grant them a license to use that copyright. Now, there's often instances where Ed Sheeran and these people are being taken to court for sampling beats. And it's always very difficult, because you think that there are only, so many notes and so many beats that are available. And it will always, at the end of the day, come to a objective approach where you would listen to the first person song, listen to those beats, hear if there's been anything that's unique. Because remember, in order for copyright to subsist, the work must be original. And people can grant you rights to use it. So even if your beats are sounding similar, if you've approached the first party and they've agreed that you can use their beats in your song, then you've got consent. Then that's not a problem, and no one's going to come after you for copyright infringement. However, if you don't get their consent and you use it anyway, you potentially expose yourself to a huge lawsuit. And once your work becomes well known and you start deriving money from it, that's when the third parties are going to cash in and say, listen, that was actually my beat that I gave to you. And they'll have record of when they sent it to you. And when the courts listen to the evidence that's presented, they will listen to the original beat, they will listen to the work, and they will then be able to make a decision. Bearing in mind that copyright covers adaptations and enhancements of the work. So if you were to take a story, for example, a Harry Potter J.K. Rowling story, and you now wanted to perhaps enhance it or even make a translation of it into another language, that would still amount to copyright infringement. So you mustn't do that without her permission. What's a very important aspect of intellectual property to remember is the value of your intellectual property is only as valuable as your willingness to enforce your rights. So if you come across a third party in the market that's using your copyrighted work or that's even using your trademark, it's very important that you send them a letter of demand and that you stop them from doing that. Otherwise, your trademark becomes generic. And there's a host of examples of trademarks that have become generic because their rights weren't enforced. For example, the Hoover vacuum cleaner, windsurfer. These are brands that used to be used to describe the goods, and now because they never enforced their rights, they have become the goods. So if you hoover your carpet, or if you take the windsurfer out, your brand has become completely diluted now and it's become the thing. And although that may sound like what it is that you want, from an intellectual property point of view, it's terrible, because what you're trying to do is create a brand that will distinguish your goods and services from somebody else. But now you get 50 different windsurfers with separate sub-brands within them. And that's not what you want. You want people to know that when they use your product, it's the windsurfer, and that's the brand that they're going to remember. Before embarking on creating a new product, first do a search at the Trademarks Office to make sure that you're not going to infringe a third party's rights. Cool. That would be the very first step. And before you sign off on a logo, ask your creative entity to make sure that they have done a search at the Trademarks Office to make sure that that logo that they've created for you is available for your use in registration in the class of interest to you. And then make sure that you take assignment of that logo so that you've got many arrows in your quiver if we ever need to institute litigation against a third party for intellectual property infringement, that you can go using the trademark route as well as the copyright route, which gives you added protection. And at least with copyright, you don't have to pay. It vests automatically in the author of the work.